there are 8 factors or 8 constituents that constitute that a marriage has broken down irretrievably, because under the Matrimonial Causes Act, a marriage can only be dissolved if it has broken down irretrievably. So the Matrimonial Causes Act did not define what it means for a marriage to have broken down irretrievably, but it gives factors and circumstances to which a marriage can be declared as having been broken down irretrievably and as such dissolved. Those 8 circumstances are: first, where the respondent, that is the party to which the petition is brought against, has failed to consummate the marriage, or has acted in such way, or his behaviors have amounted to such that the petitioner cannot be expected to live with the respondent, or the respondent has committed adultery to which the petitioner cannot tolerate, or the petitioner or the respondent has deserted the petitioner, or the petitioner and respondent have been living apart for 3 years and the respondent does not object to the marriage being dissolved, or the respondent and petitioner has been living apart for 3 years, whether or not the respondent objects to the marriage being dissolved, or the respondent has failed to comply with an order of restriction of conjugal rights, or the respondent has been absent in the life of the petitioner for 7 years, which will lead to the marriage, which will lead to presumption of death. That is, the respondent will be presumed dead, and the marriage will be dissolved. And then, what are those behaviors that will make the court declare that the petitioner cannot be expected to live reasonably with the respondent? Those behaviors are: first, that the respondent is a habitual drunkard, or always in a state of intoxication, or the respondent has a mental case or has been in a mental institution, or the respondent has failed to comply to provide maintenance as agreed between the parties or as ordered by the court, or the respondent has been a frequent convict since the marriage, or has been in prison since the conduct of the marriage. Where any of these and few other scenarios happen, the behavior of the respondent will be declared as such that the petitioner won't be expected to live with the respondent. So where any of these factors is proved by the petitioner, the court will then go ahead and declare the marriage dissolved and has come to an end. And then in some instances, the petitioner can then apply freshly and institute an action for custody or maintenance. But in most instances, both the divorce, maintenance, and custody of children are being taken as together. So with this comes to the end of this week's episode, and see you next week. And don't forget to follow us on all our social media channels. Thank you very much.